Which hand did you shoot with? Sheriff's office! Sheriff's office! Hey, come outside for a minute. Hey, come here. Hey, where's your wife at, bud? Where's your wife at?
She's dead on the floor in that room.
Clear. Hey.
That's mom.
That's mom.
Yeah.
I got her handcuffed. Alright, sweetie. Look. Let me see him step out real quick for me.
Alright, look. I need you to hold your hand out like this. I'm going to do your right hand first, okay? It's your right hand. Just like that.
Which hand did you shoot with?
Sean was killed by a stab wound to his back caused by a machete, which almost went through his entire body, was 23 centimetres deep, and penetrated his lungs and heart. There were also injuries to Sean's head, arm and thigh. The cut to the head was caused with such force it went through Sean's scalp and into his skull, resulting in a bone flap. I'm sure from the nature of these injuries that the defendants intended to kill Sean.
On the 20th of September 2024, 15-year-old Carly Gregg from Mississippi, USA, was sentenced to life in prison without parole for blowing her mother's brains out, all because her mother found out that her daughter vaped. Earlier in her court proceedings, Carly was offered a 40-year sentence but turned that down. On the 27th of September 2024, meanwhile, for hacking a young man to death with a machete in a park in Wolverhampton, England, for no reason, two 12-year-old boys were each given 8 years and 6 months. Both the USA and the UK have a common law system, a system where criminal law outcomes, mainly the sentencing element, are based on precedent. But this system has very different rules in each of these two countries clearly. And if Carly Gregg isn't at least sorry for offing her own mother, she's probably wishing that she'd at least been sentenced at Nottingham Crown Court, England, like the two said 12-year-old machete perpetrators. You know, the ones who got to sit next to mummy or nanny all through their trial and got the 13-year term that they could have been hit with reduced to 8.5 years because of their age and because their act was unplanned.
I also have to look at the list of aggravating and mitigating factors set out in Schedule 21. There is some aggravation because this was an attack by two people, but the relevant mitigating factors are the lack of premeditation and the age of the defendants, all of which I have taken into account.
Be sure to subscribe, give this video a like and drop a comment. It will mean a lot to me. Not wanting to have this video age restricted is why I may disguise certain words. In the US, being convicted of first-degree murder means that you both intended to take a life and planned how to do it. This is one of the 3 convictions that Carly Gregg now carries, the other 2 being attempted murder because she tried to off her stepfather, who has since forgiven her entirely, and tampering with evidence. We don't have categories of murder in the UK though. You're either guilty of taking a life with the intention to do so or the intention to cause serious harm, or not. Whether or not you actually planned a way to do the act doesn't lessen your liability for the act, but, as I've already shown, it does lessen your sentence. So, where being convicted of murder is concerned, Carly Gregg is unlikely to have derived a different outcome at Nottingham Crown Court or anywhere else in England and Wales to the one that she got slapped with over in Mississippi. The machete perpetrators had to be tried at the Crown Court since their alleged offence, murder, is an indictable-only offence, making it impossible for it to be heard in a lower court, namely the Magistrates' Court, or, more relevantly for these two perpetrators, the Youth Magistrates' Court. These two lower courts have very limited sentencing powers, a 2-year prison term being the longest that they can hand out, and the magistrate, him or herself, serves, literally, as both judge and jury because there is no jury. But unlike Carly Gregg, the two perpetrators, who I'll call John and Steve since their true identity remains protected by an anonymity order, were by no means tried as adults. I don't just mean that they were allowed to play with fidget spinner toys while giving evidence, or that they were allowed to sit with a family member in the main well of the court rather than in the dock like other defendants who were in custody, or that for their benefit the barristers and the judge didn't wear wigs or gowns. I mean, far more significantly, that despite being tried for MUDER at the Crown Court, John and Steve were shielded from a sentence of any longer than 13 years on account of their age and on account of the unplanned nature of their act. At the Crown Court then, it is 99.9% certain that Carly Gregg wouldn't even have come near getting a whole life order. In fact, unlike in the US, in the UK there are, as at October 2024, fewer than 80 prisoners serving one such sentence. Carly Gregg might have got around 15 years, like the boy who, in 2006, aged 15 or 16, unalived up-and-coming Queen's Park Rangers football trainee, 15-year-old Kyan Prince. That said, on account of her accompanying convictions for attempted MURDER and tampering with evidence respectively, Carly Gregg may have got somewhat longer, unless her sentences for those two offences were to run concurrently with her sentence for MURDER. But whatever her sentence would have been, it would have been capped at a fixed number of years and have been substantially shorter than if she'd been 18 or older. But over in Mississippi, not only was Carly Gregg tried as an adult, she was also sentenced as an adult. That's the whole point, clearly, of trying a juvenile as an adult, at least in Mississippi. Carly has since filed a motion for a new trial, where she obviously hopes for a lighter sentence. But the state of Mississippi, along with others, is no less fully entitled by law to lock juvenile unalivers up for life, unlike in the UK. In the UK, where criminal responsibility kicks in at the age of 10, a person aged 10 to 17 is never tried as an adult.
All right, the verdicts appear to be in proper form. Verdict of the jury is count 1. We, the jury, find the defendant, Carly Madison Gregg, guilty of first-degree murder as charged in the indictment. Count 2. We, the jury, find the defendant, Carly Madison Gregg, guilty of attempted murder as charged in the indictment. Count 3. We, the jury, find the defendant, Carly Madison Gregg, guilty of tampering with evidence as charged in the indictment. Please be seated, Ms. Gregg. All right, ladies and gentlemen, with you having returned a verdict of guilty in count 1 and count 2 of the indictment, we'll now proceed to the sentencing phase of the trial. Your sentences will be as follows. As to count 1, the jury having fixed the verdict at life imprisonment, this court will sentence you to life imprisonment. As to count 2, you'll be sentenced to life imprisonment. As to count 3, you'll be sentenced to 10 years to serve.
The criminal justice system of the UK seeks to bring about the rehabilitation, in particular, of young offenders.
Because our prisons at the moment are terrible, terrible places. They're lawless, they're violent, they're destructive. And you know, I take the case of Thompson and Venables as very illustrative of this point. We know with John Venables, for example, that having been released from prison custody, he's behaved abysmally and has been returned to prison custody. Robert Thompson is slightly different though, and the way that we deal with young people when we incarcerate them as young people is very much focused in the first instance on rehabilitation, on education, on trying to kind of deal with and address those problems that were likely there within them before we put them into an adult state and seeing if we can get them to a stage where they're not going to reoffend again. Now the problem is when we
If, in contrast, Carly Gregg, over in Mississippi, US, ends up spending the rest of her life in prison, it will hardly matter if her character isn't rehabilitated. Rehabilitation can hardly be the aim of her sentence. Punishment of the offender, along with protection of the public, though, are justifiable purposes of her sentence. This is what the law of Mississippi clearly seems to say. Is UK justice too soft? Would we prefer John and Steve to be locked up for life for what they did, like Carly Gregg? If not, given that no sentence can ever bring their victim back, what is the minimum sentence for the machete perpetrators that we, the public, would accept?
The facts of this case are horrific and shocking and can be explained very shortly. The first defendant bought a machete from a friend in October last year for £40. He kept it under his bed. On the 13th of November, he came home from school, got changed out of his school uniform into a tracksuit, picked up the knife, left home and met up with the second defendant, a friend from school. They then met up with other friends, and by early evening they headed to Stowlawn Field, where they were soon after 8 p.m. Sean Cisahay was visiting Wolverhampton with a friend, and earlier in the evening they were sitting on a bench in Stowlawn Field chatting about their plans for Christmas. About 8:15 p.m, Sean and his friend left the bench and walked away from it past the defendants. The defendants were then at the bench. Sean returned after a few minutes, spoke to the defendants and asked them to move. Moments later, he was dead. Part of the report deals with the assessment of the first defendant, including consideration of safety and welfare issues. This section in the report details the extensive involvement of children's services in the first defendant's life and the reasons for that. The report also explains, amongst other things, that the first defendant has been referred to mental health services and there have been instances of self-harm. He was diagnosed with ADHD in 2022. It is in this context and against this factual background that the report says this, and I quote, "Having spoken with the first defendant and consulted records held about him, we would assess that the first defendant seems to function at a lower level than his chronological age, both in terms of understanding and his emotional literacy. The first defendant is a child with extremely complex needs. He has experienced violence from within the home from an early age. It is clear he has experienced change, loss and unpredictability, which must have an ongoing impact on his sense of identity and belonging. His experience of such developmental trauma is highly likely to have had a negative impact on his cognitive development, his ability to regulate his emotions in the moment and to take informed decisions. He was made even more vulnerable through his ADHD diagnosis." The report then continues by saying that there is a professional consensus of opinion that the first defendant was being groomed and exploited, and that in the professional's view his experiences in this respect contributed indirectly towards his participation in Sean's murder. Another part of the report assesses the risk to the community, including the likelihood of reoffending and risk of serious harm to others. This explains that at the time of the offences, there were significant concerns about, amongst other things, the first defendant's access to knives, exploitation, and how easily he was influenced, which meant that the likelihood of offending and serious harm were very high. The authors of the report note that this has to be seen in the context of the first defendant's very many adverse childhood experiences. He is now in a safe place where people will help him, and he has undertaken meaningful work which is helping him to make positive changes to his thoughts and behaviours. They are hopeful that his secure placement will result in further reducing his risks in the future. The report also explains that the first defendant has spoken about what he did, that he said it is not fair that someone lost their life, and he feels sad about it. He said he feels bad that he took the knife out with him, and he wished things had gone differently. The starting point of 13 years needs to be adjusted downwards because the first defendant's chronological age was that he'd relatively recently turned 12 at the date of the offence. I then have to take into account that at the time of the offence, his emotional maturity and developmental age were less than that. He has been adversely affected by multiple traumas throughout his childhood, for which he is and cannot be responsible. These are all factors which diminish the culpability of the first defendant. The first defendant always accepted he bought the knife and took it to the field, and he's shown some insight into the harm he has caused. But I agree with the authors of the pre-sentence report that he does not at this stage have the maturity to fully appreciate the consequences of his actions. On top of that, he's making progress with his behaviour and education in the stable and settled environment where he is living, and that should continue to progress. The first defendant did not have any previous convictions, but he was known to the police and had been carrying knives. But that has to be considered in the context that he was the victim of trafficking and extremely vulnerable. I have taken into account everything I know about the first defendant and what he did, and in my judgment the minimum time he should spend in custody is 8 years 6 months. From that must be deducted the 315 days that he's already spent in custody. The first defendant will remain on licence for the rest of his life. This means that there are conditions that will be decided when the parole board decide it's appropriate for him to leave custody, and he will have to follow those conditions for the rest of his life, and if he does not do so, then he may have to go back to custody. I now turn to the second defendant. The second defendant was much closer to 12 in age than 13 at the date of these offences. The report explains in detail the second defendant's background and upbringing, the upheaval caused to his childhood by moves in the location of his family's home, some of which was spent in a refuge, and the disruption this caused to his childhood. The second defendant has a supportive and loving relationship with his parents and his brother. He was not known to social services or the police at the time of the offences. The report explains that the second defendant expressed that he feels remorse for what happened, and he feels sorry for Sean's family and understands that they are suffering greatly having lost their son. It is possible that the second defendant has dyslexia, but that's not yet been confirmed. In terms of risk, at the date of the report, the second defendant was assessed as a medium risk of reoffending and a high risk of serious harm to others. The report then says that it's important that he continues to engage with the support and interventions where he's living, as that will give him something positive for his long-term future. The authors of the report accept the serious nature of the offences and what the second defendant has done, but comment very positively on his behaviour since he's been on remand, his motivation to do well and to achieve qualifications. The report also makes clear that whilst he is physically mature for his age, he is still young, and it will take time for him to mature emotionally and developmentally in an environment where he feels safe. The starting point of 13 years needs to be adjusted downwards because the second defendant's chronological age was that he'd relatively recently turned 12 at the date of the offence. His emotional maturity and development age was not below his chronological age. He does not have any mental health problems but may have dyslexia. I then have to take into account that he's now showing maturity beyond his years. He is responding very well in custody. He was of good character and has shown remorse for what has happened. I have taken into account everything I know about the second defendant and what he did, and in my judgment, the minimum time he should spend in custody is 8 years, 6 months. From that must be deducted the 315 days that he has already spent in custody. I appreciate that this is the very same as for the first defendant, but having applied the guideline, the factors that have led me there are different. But when I have considered and balanced the individual features of each defendant, that is the clear conclusion that I have reached for each of them. The second defendant will also remain on licence for the rest of his life. This means that there will be conditions decided when he leaves custody, which he will have to follow for the rest of his life. If he breaks those conditions, then he may have to return to custody.
Carly Gregg's defence team tried to mount a defence of insanity but refused to disclose Carly's medical records, which meant that this proposed defence of theirs got nowhere. Carly ended up pleading not guilty by reason of insanity, but just not guilty. Carly vaped, smoked weed and self-harmed. As a result of these things, she'd been put on antipsychotic drugs. When those didn't seem to be working, her doctor switched her over to a drug called Lexapro and just hoped for the best. Lexapro, you see, is what doctors give to patients, apparently, when they just don't know what else to do. Eerily enough, Carly committed her offences 5 days after starting on Lexapro. But was she, at the time that she committed her acts, certifiably insane? In court, it was revealed that Carly had told others on numerous occasions before the day of her act, a period that went back much further than the 5 days that she'd been taking Lexapro, that she wanted to unalive her mother. She was sick and tired of her mother's controlling ways towards her, you see. Carly hid the gun that she used on her mother from the cameras in her home. Straight after blasting her mother into oblivion with 2 shots to the middle of her face and 1 to her chin, she tried to lure her stepfather home by texting him from her late mother's phone, imitating her mother. You'll soon see why she did this. From her own phone, she then texted about 6 of her friends, inviting them to come over and gaze at her mother's corpse. One friend actually did come round, and Carly told the girl, Brittany, that she'd used 3 bullets on her mother and saved the remaining 3 for her stepfather. This is why she had texted her stepfather, pretending to be her mother. She wanted to know when to expect him home. On subsequently running out of bullets for her stepfather, who she shot at the second he opened the front door on getting home, but who she failed to unalive, Carly dropped the gun and ran for her life. In UK law, your insanity defence has to meet the criteria for diminished responsibility, which usually spares a person from a life sentence. The criteria being the defendant was suffering from an abnormality of mental functioning which arose from a recognised medical condition, substantially impaired the defendant's ability to do one or more of the following: understand the nature of their conduct, form a rational judgment, exercise self-control, and the abnormality of mental functioning provides an explanation for the defendant's acts and omissions in doing the unaliving. While it's clear from the fact that she hid the gun from her home cameras and then ran away after failing to take her stepfather's life that Carly did understand the nature of her conduct, we outsiders can't answer the other questions that these criteria require us to answer. As such, we outsiders don't know if Carly was insane at the moment when she committed her acts. Her history of medication, substance abuse and self-harm are by no means conclusive proof of insanity on her part. As regards US law, I don't know what their criteria for certifying a defendant insane are. Unlike in the US, in the UK, juveniles usually have their identity concealed until they're convicted, if that's what actually eventuates. Trials aren't broadcast either. It's only in the last 2 or 3 years that sentencing remarks, which are just the final element of a sentencing hearing, not the whole of the hearing, have been broadcast. But even then, we only ever get to see the judge. We never get to see the defendants, who are by now convicts, even when they've already been named and shamed and shown in the media. By the sentencing stage, juveniles, to remind you, will usually have been publicly named. There are ethical questions, many agree, around making entertainment out of crimes as serious as unaliving. The victim's family may understandably be outraged and upset by this. On this very point, I think we'd all prefer it if Carly Gregg, John and Steve just hadn't harmed anyone at all for any reason. If you've enjoyed this video, I recommend you to watch this one next. I'll meet you there.